Dear colleagues, good afternoon. I think it's time we start. And to start, I would like to congratulate the organizers of the St. Petersburg Legal Forum for the wonderful setting, for this opportunity to express our positions and discuss the most recent changes and developments and trends. Let me start by introducing our speakers. We have Chiracha Intachan. She's Secretary of the Central Tax Court of the Kingdom of Thailand. Timothy MacDonald is Vice President for Finance and Accounting, Procter & Gamble. Peter Reinhardt from Ernst & Young. David John, he is Executive Partner in the CE PricewaterhouseCoopers. Anandajan, Secretary of the administration in India, Sergey from St. Petersburg University, Dmitry Kornev is Director of Tax at the MTS, and myself is Sergey Arakelov, Deputy Head of the Federal Tax Service of the Russian Federation. And I am very grateful to all of the panelists for the agreement to contribute to this discussion. We believe this is a very exciting topic, which has been evolving globally. But before we start discussing this issue, I wanted to talk about the way Russian tax administration is trying to approach this issue. Over the past 5 years, the Russian Federal Tax Service has been working consistently to develop administrative procedures to help mediation and amicable settlement. As you can see in the slide, since 2009, we have a procedure in place which allowed for pre-trial resolution of disputes. This is an administrative procedure which is part of the on-site and off-site tax audits. Then moved on to the so-called pre-trial resolution for all kinds of disputes pertaining to taxes. Has been in place since 2014, and then we extended this pre-trial procedure to issues of registration. And what we have found out is that over the period, we saw the number of disputes in courts diminishing significantly. The number of complaints went down, and this is an important indicator, because if you go back to what we had in Russia 5 years ago, both courts and tax authorities were overburdened with the number of complaints, disputes. So we decided we need to have this model in place. As you can see, there was a 30% cut in the number of actions, and we see some positive developments. Our prediction is by 2017, another 30% cut will be achieved. We also see that, and you can see it from the slides, the number of disputes adjudicated by courts was evolving. The trend is continuing, and we saw 8% cut in the number of disputes involving tax authorities and courts in the first quarter this year. And of course, this is an important target for us, which is the number of litigations that we have to do in courts. Going back 5 years, we had by amount of by the amounts in disputes, we had about 40% now by number of by number of awards given to us, tax authority, we achieve 80% success rate. So we have significantly optimized our litigation services. We have introduced a completely different procedure for monitoring the litigation process in the commercial courts, and now at the Supreme Court. We have very important filter at the Central Tax Authority, where all litigations is being handled, and they monitor all the litigations across the country. And it's been very positive. We also thought we needed to be more public for all of our decisions, and all the rulings that pertain to the pretrial resolution are downloaded and published in our website. It's open public domain. You could learn about the position of the tax authority. We also have a special service of the tax federal authority, which is basically our instructions, explanations for our territorial branches, so that all our territorial branches, we have over 1,000, would follow uniform policies. You will probably remember how those amicable solutions, amicable settlements procedures evolved, where the tax authorities could negotiate taxpayers. There were many opponents. They argued this was not the way to go. But the Supreme, or the High Arbitration Court, the High Commercial Court, puts a stop to all those arguments. We now have over 40 pretrial agreements and with taxpayers. And another important development was the introduction since the beginning of this year, the so-called horizontal monitoring. It is called tax monitoring in our law. And again, we believe this is an important change, because it will make our position more understandable, clear, and we try to avoid litigation as far as we can. Since 2015, taxpayers have an opportunity to enroll in this procedure, and we worked very hard on our pilot project involving 5 companies. This was a horizontal tax monitoring pilot project. We saw that this procedure has a very bright future, and I'm not exaggerating. I'm sure that we'll be moving away from the traditional control measures and the system we have now in place under the tax code in the form of off-site and on-site inspections, and we'll go somewhere else. This may take another different roundtable discussion, but we're moving to a different model. You've probably heard about a new control model for VAT payers. So I think this is a future not for tax audits for each and every taxpayer, but for risk-oriented approaches that are based mostly on our monitoring of those taxpayers who may be relying on tax avoidance. At this point in time, we have good grounds for trying to introduce tax rulings. We have those mediation procedures. We also have the important roadmap, where the issue of tax rulings is one of the priorities, and the basics of our tax policies for the next 2 years also provide for us to move in that direction. So before the end of this year, we will have drafted a relevant law for the State Duma to consider. What is the advantage of tax rulings in the Russian Federation? That would improve the certainty, that would help us avoid unpredictable risks, that would improve transparency of the tax regulation. For us, for ourselves, this is an important step because we will understand better the tax services at companies, and we will be working with those who rely more and more on tax avoidance, who act aggressively in that respect. This slide summarizes this concept of the tax rulings, advanced tax rulings, and it appears to us, and we may be wrong, this is something for us to discuss today, that at this initial phase, this procedure probably be better launched for the larger taxpayers, so the biggest taxpayers. At the moment, we are considering what sort of issues should be part of the purview of the tax ruling. There will be a certain time given after the application, and again we are discussing for how long, and based on the consideration of application, we will be sending the taxpayer our substantiated ruling. The taxpayer then will not have to pay any penalties and fines. So we also thought of introducing a kind of a mediation procedure. Since the issues at stake are quite sophisticated, so it would make point to involve some third parties to the procedure. We may be allowing for involving some experts, specialists, professionals who could contribute to this procedure. Also, and this is something we need to discuss today, and some of the most painful issues that we have uncovered as we were working on this draft law, we try to summarize here. Should this procedure be free? Should it be subject to a duty? Also, we need to define the range of taxpayers who could apply. For us, we would want to start with the larger taxpayers. What sort of issues can be discussed as part of this tax ruling procedure? Whether these rulings should be extended to the proposed or completed deals, whether we need to decide on the methods of post control. Should we allow third parties who could act as mediators? What would be the effective period of the tax ruling? And finally, whether these rulings could be amended, whether it is possible for the tax authority to change its position going forward. So these are some of the issues we are facing at the moment. I'm quite prepared to accept there will be many more as we go, but we would like to cover those with the help of our panelists. And before I give the floor to the next speaker, let me point out that this forum is unique because it is our fifth time that we participate here. Before that, we discussed pre-trial settlements and tax monitoring, horizontal monitoring. We expressed our position here, and then we drafted the law. So we have hope that some new steps will happen. And I'd like to give the floor to Peter Reichertz. I have the following question to you, Peter. I wonder if you could comment about mediation procedures and about rulings in the United States, whether these rulings are effective, and what do you think about the prospects for Russia? Thank you very much, Sergey. It was my pleasure to comment all of those issues based on what we know from the United States and rulings there. I would like to start by saying that the United States, we have quite a long list of available tools and instruments for the pre-trial mediation. So apart from the tax monitoring and the CAP program, we have advanced pricing agreements on transfer pricing, and I'm sure we'll discuss that later on. We also have at least another 5 different formats of consultations to which you could rely if you're a taxpayer. But let me pick on one of these, and this what we call private letter rulings, because it's the closest to what you propose as the next step in Russia. And we're hoping that Russia would follow that procedure after our discussions. The ruling instrument has been around in the United States for decades, and talking about the principles of applying in the experience that we've amassed. If I'm to talk about the principle, about the coverage, it works for everyone. It works, it is open both for individuals and legal entities. This is a very democratic tool in that respect. If we are to discuss the scope of that procedure, it has a very wide scope of tax issues. Those rulings could be issued to specific transaction. For example, on issues of the tax period, the method of tax accounting, any issue of corporate tax, and various procedural and administrative issues that could be ambiguous and where you would want to agree or get the right answer. There are a number of other areas where you can't get the tax ruling, and every year the Internal Revenue refreshes this list of areas, and there are some general ones where you can't get the ruling. For example, you can't get the ruling where we have an ongoing litigation on the same matter of tax law, and I think you understand why not, because we need to wait till the court awards its decision. We can't give any ruling before that. You can't get a ruling from Internal Revenue to a part of the transaction, because we need to see, or rather the tax authorities need to see the whole picture for them to issue the ruling. And you can't get the ruling if the answer is clear from the tax law. That is when you already have the objective answer. It's another question, of course, what is objective or not. And this is the principle.
And finally, you cannot obtain a ruling with respect to a hypothetical issue, which means that the ruling should specifically apply to a particular transaction or a concrete situation that the taxpayer finds themselves in. Now, what about the implications of using the ruling procedure? They are as follows. Well, first of all, the statement that is found in the ruling is after that applied during tax inspections. The tax authority must be guided by the ruling on a number of rather simple conditions. First of all, the first condition is that the taxpayer should be applying that ruling in their tax declarations and their tax documentation. The facts that were presented should have been presented fully and truthfully, and also the economic operation or the business operation in question should have been conducted in the manner as was described. Then also there shouldn't have been any significant changes or amendments to the tax legislation. If all these preconditions are met, then the ruling is fully applied, fully applicable. Now, what about the revocability and the timing of revocation of a ruling? And this is something that is being very actively discussed with respect to the Russian system. There is only a very limited list of cases where that works in the US. It only is possible if there was a concealment of facts or the absence of material facts from the by the taxpayer. It is possible if significant changes have been made to the tax legislation ever since the transaction occurred, or if there have been significant errors committed by the taxpayer. Otherwise, the ruling will remain effective, and there is no possibility for the Internal Revenue Service to say one thing, but then the Treasury would say something else, or some matters may have arisen that would render the ruling invalid. The ruling remains effective indefinitely, and I must say that the ruling process is rather expensive, but sometimes it can be quite affordable. Of course, it all depends on the type of subject under consideration or the size of the taxpayer. It may cost anywhere between $4,000 and $30,000 every year. This cost level goes up because of the inflation. What I'm giving you is for 2015 only. But again, we're trying to be more or less democratic here with respect to the small businesses. Small businesses are eligible for discounted rates. Now, what about the procedure itself? The application should be made in writing. This is mandatory. The application should be made before filing your tax declaration. The application should meet all the requirements and preconditions that I described to you. Next, the application will certainly be considered by the Internal Revenue Service. Before considering the application, it is possible for the taxpayer to meet with IRS officials upon request, and this, by the way, is a very good example of how this tool has evolved in the US, because initially we didn't have this pre-meeting option. Currently, it is an option, it's available, and sometimes it's very helpful for both sides. Because from very early on, they can clear out whatever misunderstanding there might arise regarding the matter. There is a 21-day period for the IRS to provide their first response to the applicant. They may request additional information or documentation if necessary. They will have communicated their initial position on the case to the taxpayer within that period of time, and if the IRS only observes that several minor adjustments in the structure of the transaction could improve the outcome significantly, they can get back to the taxpayer asking them to do so. The taxpayer has 21 days to respond to the IRS before the ruling is issued. They have the opportunity to hold preliminary discussions of the ruling with the IRS, or they may withdraw their request for ruling sometimes. And it happens from time to time when the taxpayer anticipates an untoward response from the IRS. In that case, the situation is resolved using the traditional mechanism, which is still in place. Overall, we're talking about some 180 days for the whole process. And I must tell you, Unfortunately, this is not always the case. This is not always observed. Sometimes a year or even 18 months are spent in the process, especially if the matter relates some international businesses. We have an absolute record of 3,000 something days. This is how long the procedure lasted, about 10 years, but this is rather an exception, I would say. Usually it's about a year. To sum it up, what are the lessons learned from our experience? I think overall the experience has been extremely positive, both for the IRS and the taxpayers. Obviously, it helps to prevent disputes whenever clarity can be achieved before litigation. It reduces the administrative burden on both sides. And incidentally, it also helps the IRS in that it works as a tool for identifying gaps, ambiguities and disadvantages in the current tax legislation. So this is a way to review our tax policy, to plan for legislative amendments, and to make the situation better for all of us. So overall, the experience has been rather positive, but there's still room for improvement. As always, we have to work on the time frames and time limits. Sometimes they are not enforced because of the lack of capacity within the IRS. And this is the reason why, in my opinion, every year we only issue about 1,000 rulings. And this number hasn't been growing. It's very important to ensure adequate internal governance and adequate distribution of duties and tasks between various officials so as to spread the burden more or less uniformly. It's also a matter of perception. The relationship between the two sides should be based on high caliber professionalism. We have seen these programs implemented in several places recently, and there is always a risk of a political nature, a risk of the new program being misperceived. So governance is essential. I fully support Russia's plans to implement this step, and I do hope that the experience so far in countries such as the US will contribute to your success. Thank you very much, Peter. I have a clarifying question for you. You said it takes 180 days. This does seem like a lengthy process. Again, disregarding longer exceptions, there's still a clarifying question on my part here. Does a ruling apply to a past transaction, a completed one, or to a potential transaction? Because if we're talking about a transaction that's still being planned, this long time frame will certainly impact the taxpayer, because the taxpayer will have to be waiting for the IRS to come up with a decision, and if there is this long time involved, that creates some pressure on the taxpayer. Have you faced these situations? Yes, we have, and we continue having them. In response to your first question, the ruling is forward-oriented. It's revolving around future transactions. That's how it works here. We are talking about situations that have not yet been reported in tax declarations. Yes, indeed, in the business world of today, sometimes transactions evolve very quickly, so decision-making should keep pace with that, and you don't have the luxury of waiting for 180 days in some cases. Nevertheless, a lot of things are negotiable. If you discuss this very early on at the first meeting and we come to an understanding of the subject matter, and if we understand that this is a complex issue, it may still take some time. In that case, the taxpayer may decide against the process, or they may wish to resort to a different process. Peter, has the IRS ever faced suits from taxpayers who did not get a ruling in a timely matter and would go to court? Because I cannot rule this out in Russia. This is one of the risks that we have in mind. So have you seen any such developments? I don't have any direct experience with any such cases. It doesn't mean they didn't happen in the past. Perhaps Timothy, who has a lot of experience practicing in the US, he may have seen something like that, but I don't remember anything of that nature happening. Thank you very much. Now I would like to turn it over to David John. David, let us hear from you about the experience of the UK. And I have a more precise question for you. What about follow-up control? I mean, how does it happen? What happens actually after a ruling has been issued?
Thank you. Sorry. I'll cover the UK system of rulings over the next few minutes, and then conclude with some personal comments about advantages and disadvantages. So the UK has a system of rulings. We call it in English clearances. Those are both statutory and non-statutory. So in rather complicated parts of the legislation, it is provided for the tax authorities for taxpayers to apply to the tax authorities to obtain rulings on particular transactions, and those tend to be very defined and rather complicated ones. So the tax implications in the UK of a share-for-share exchange or a demerger, where certain reliefs are provided, you can actually request information and confirmation that your transaction will give you the tax consequences that you expect. We also have a system of non-statutory rulings. And non-statutory rulings essentially mean that you're able to write on any matter whatsoever to the tax authorities and ask them to confirm their view of the tax treatment. However, there is a limitation on that, which is there must be a material uncertainty in the legislation, and where the legislation is more than essentially 4 years old, the issue must also be commercially significant. And as there's probably a lot of lawyers in the room, you'll be very pleased to know that even after 200 years of an income tax system in the UK, there is plenty of areas for uncertainty and where disputes arise in practice. One step the UK has introduced, which has fitted on top of the ruling system, is our version of horizontal monitoring or real-time audit, where medium and large-sized taxpayers can essentially obtain a very high level of certainty on all aspects of their business through that system without the need for rulings. So just as Peter was saying, actually, for the US system, the UK system is similar in that for statutory clearances, they can be fully relied on as long as all information provided is accurate and all material facts are disclosed. If not, then the ruling can't be relied on. So it's very important that all information is provided to the tax authorities. On non-statutory clearances, we have a quote, some very nice words from the Inland Revenue, but if I was to summarize it, certainty provided by rulings is a very good thing, but resources are not infinite, and therefore there are restrictions provided by essentially the UK tax authorities on which areas they will give rulings on or not. Otherwise they would simply be drowned by the volume of requests. There is actually also in the UK a general anti-avoidance rule, and as a matter of policy the tax authorities will never give a clearance in respect of that rule, although usually it's only applied in situations where there's quite clear abuse. The main features of our system, so only HM, Revenue and Customs, the tax authorities can provide rulings. All statutory rulings are provided by one separate team. All rulings are private, so made to a taxpayer, and they're not made public, and they only cover a particular transaction. They are binding on the tax authorities, as I mentioned, as long as all facts are disclosed, and it is possible for the tax authorities to refuse to take a question and to answer it if they choose to. There is no fee, and the time limit is 28 days, and in most cases the tax authorities manage to meet that timetable. The tax authorities themselves do all the rulings. There is no use of third-party experts. Within HMRC there are many specialist units, and all particular questions about particular areas of expertise will be referred to them. Once you have a ruling, when the tax authorities audit or initiate an inquiry into a particular open year, it is entirely up to them to check the facts and make sure that the facts that were provided to the authorities that gave rise to the ruling are actually followed through in practice. And typically, facts are provided by the taxpayer. The authorities then provide their view on those facts, and there isn't a very significant request for lots more information in order to provide that opinion. That's the system. I'd just like to make a few sort of personal comments on it and the advantages, which I think will be important as Russia considers whether or not to implement similar arrangements. So in principle, of course, rulings are a very valuable instrument for taxpayers. In my experience, most significant, large, mid-sized taxpayers, what they really want is certainty in their tax affairs, and they really hate large and late surprises. A number of tax systems these days attempt to provide certainty through rulings, but also through horizontal monitoring or real-time audit systems. In my experience, that system can work extremely well, but only if the tax inspector that is running that particular program is able to make decisions. And if you have a tax inspector who struggles to take responsibility for making decisions, the system doesn't work very well. So it's very dependent on the individuals and the trust that is built up between those individuals. Having said that, rulings are extremely useful in providing certainty for significant amounts of money where there is significant uncertainty. And although in the UK case, if you get a ruling, you get it quite quickly, and it usually is very valuable, particularly if it confirms a particular set to the tax treatment that the taxpayer believes should apply. But in fact, there is quite often a lot of requests, and you have to be very careful that you don't overburden the system. And as a last point, enhanced relationship, and by that I mean horizontal monitoring, the use of advanced pricing agreements and rulings on unusual transactions. If you put all of those together, you have a mechanism to, in theory, completely de-risk tax compliance. And I would just like to stress that in my experience, de-risking tax compliance is an extremely valuable thing for taxpayers and for the country that is able to provide it. Tax is an important part of investment decisions, and where certainty is achieved, there is a higher degree of attractiveness of that location for investors. Thank you.
Thank you very much, David. I would like to ask a clarifying question. In the system of tax authorities in the United Kingdom, is this issue taken by any tax authority, or you have a special team that would get all of the applications to consider?
Statutory rulings, which tend to be on very complicated and difficult matters, there is a central team. For non-statutory clearances, which is basically any question, you apply to your local inspector, and he will reach out within the tax authorities to the relevant specialist if he needs that input.
The reason I asked was that we were going along the route whereby we would get a special team which will belong to the central headquarters division. So at least for the first phase, at least at the beginning, so that we could help the territorial branches from the headquarters. Thank you very much, David. And now I'd like to give the floor to Ms. Tannen. I understand that in India you have rather a common practice as far as tax rulings are concerned. Well,
less than 50, but more than 20.
Is it current that states uses?
No, it's also been around for decades in the States. I can't give you the precise year, but I believe it has been around longer than I have been around. So a long time.
Итак, возвращаясь к вопросу.
well, going back to my question I had. As far as I know, you have a system in India, but you also have an important limitation. Not all transactions, not all taxpayers. Could you talk about the scope of this mechanism? What sort of transactions are included? And then my second question is, what do you think about this procedure in India, whether it has been successful for India at all?
Thank you very much. First of all, thanks for inviting me here. It's a pleasure to be here, and I can see that the session is got a lot of attention from a lot of people here. Yes, as I was listening to the UK system and the US system, I was struck by how much similarity there was with our system, but there are also a few differences. I will basically mention the main features, and I would be glad to take any questions, including the questions that you have already mentioned. We have advanced tax rulings in India since 1993, and not everybody can approach the come forward for advanced rulings. This applies only to a non-resident who undertakes any transaction which may have tax implication in India. It also applies to a resident who might undertake a transaction with a non-resident. Then it applies to public sector units. This was done specifically so that government-to-government disputes are minimized. So public sector units can take any type of dispute to the advanced ruling authority. Then any person can approach the advanced ruling authority for an impermissible avoidance agreement. My colleague was mentioning about the anti-avoidance rules. So we also have an anti-avoidance regime in India, which is actually not kicked in. It is kept on getting postponed because it's highly controversial. But eventually it will come in, and anybody who feels that his transaction might be treated as an anti-avoidance, come under the anti-avoidance rules, he might also approach the advanced ruling authority. Very recently, we have added one more category that was in the last 6 months. That is that where very large cases, a resident can also approach. That means cases involving a potential tax demand of 100 million or more rupees. They can also go to the advanced rulings. Now, the questions on which the advanced rulings can be sought, it could be, that as somebody else also mentioned on the panel, there can be no ruling on a purely hypothetical question. It has to be either a transaction or a potential transaction which is going to take place. The question raised in the application should not be pending before any other income tax authority or appellate authority under the Income Tax Act. It should not be already before another authority. Then it should not involve the determination of fair market value, because this expertise is not with the Advanced Rulings Authority. There are some transactions in India where the tax authority needs to determine the fair market value of an asset. So those kind of questions cannot be taken to the AAR. AAR is the authority on advanced ruling. And these are the major limitations. Application has to be made in writing, as I think everywhere else in all other systems. There is a small fee involved. It's quite nominal, actually. It is 10,000 Indian rupees. And that would be, you can sort of divide it by 1.25 in order to get the rubles, or by 62 rupees if you want to get the dollars. So far as the composition of the AAR is concerned, here we have a slightly different system from the rest of the world, I think. It is headed by a retired judge of the Supreme Court. The Supreme Court is the apex court in India, the highest court. And the chairman of the Authority on Advanced Rulings is a retired judge of the Supreme Court. And it's a separate statutory body. It is not a part of the tax authority at all. And a vice chairman is there, who is a retired judge of any high courts. In India, we have, I think, about 24 high courts. And the vice chairman could be a retired judge of the high court. Therefore, this authority is a very high-level authority, and therefore the appeals from this authority cannot go to high court or to any lower court. To Supreme Court it can go. In fact, there is no appeal provided, but you can go in writ as a constitutional remedy. I'm sure everybody appreciates what a writ is. As a constitutional remedy where there is a breach of a constitutional right or a right or any other right, then it can be taken in that form. But as such, there is no appeal from the determination of the Authority on Advanced Rulings. It's an independent adjudicatory body, and it's not part of, as I mentioned, Finance Ministry or any other government ministry, department. The ruling, as I think in the case of UK and also US, is to be delivered within 6 months. But again, it is not mandatory. It can take much longer than that also. It is not a compulsory limitation. It is an indicative limitation that it should be done within 6 months. The ruling is binding. It is binding both on the department as well as the applicant, but it is only binding in respect to the particular transaction or transactions in relation to which a person approaches the Authority of Advanced Rulings. And otherwise, it does have a great persuasive value in any legal disputes, whether the same type of transaction arises before the advanced rulings authority on a later date, maybe in the case of a different taxpayer, or even in the case of the same taxpayer, or even in the lower courts, let us say the tax tribunals and all, the decisions of the authority on advanced rulings are treated with respect and often followed. Then what else? Yeah, what are the benefits of advanced rulings? I think they are the same as elsewhere in the world. It helps the applicant in planning his income tax affairs well in advance. It brings certainty to the determination of tax liability, and uncertainty is one of the worst things that you can have in tax laws because it discourages business and runs into litigation for years. Then it helps avoid long drawn-out expensive litigation. It is inexpensive, it is expeditious, and it is binding. These are the advantages. And so far as the main issues that are normally brought out before the authority on advanced rulings, and these would be in the cases of non-residents mostly, conflicts arising from difference between the double taxation avoidance agreements and the domestic law provisions, the determination of residency status, because this determines the tax liability, the determination of permanent establishment, existence of the permanent establishment or otherwise, capital gains as to where the asset is located, especially in the cases of securities and stocks, etc. Then taxation of services, royalties, fees for technical services, etc. And taxation of foreign investments, etc. These are some of the main issues which the authority deals with. The cases, as we have seen, as compared to the total amount of litigation that exists in tax cases, are few because of many problems with the AAR thing. One is that, first of all, the binding, sometimes, as somebody else also mentioned, that the questions, the AAR takes 6 months. In the meantime, there is nothing to stop the tax authority from going ahead and assessing the income of the taxpayer, because there is nothing which bars the jurisdiction of the assessing officer while the tax application is in process. I will not take much more time because I think time is running out. The time limit is only indicative, and many times we have had administrative problems also in appointing the right persons, because the field of appointment, as I said, retired judges of Supreme Court and High Court, sometimes they are difficult to find for this purpose. These are the main problems.
Спасибо, Веллер. У меня, может быть...
Thank you very much. Did I understand you correctly that this position of AAR is binding both for AAR as well as the taxpayer? So the ruling is binding, right? Is that so? Okay, thank you. Because this is something that we've been battling with. This is indeed debatable. How do we go about situations when the taxpayer does not agree with the tax authority's ruling? Should they be entitled to appeal the ruling? Is there an appeals mechanism in place? So what can a taxpayer do in that situation?
As I mentioned, there is really no system for appeals in these cases, because the authority is an independent and very high-level authority in our case, not a part of tax department. So that could be a problem which discourages the taxpayers from going to the authority on advanced rulings. But what we have seen is that people are, although in the tax code there is nothing for the taxpayer to go in appeal, but people are going through the constitutional mechanism that is challenging the legality of something that is there in the order, and that way they are getting, and sometimes Supreme Courts are delivering their orders also in such cases.
Спасибо большое.
Thank you very much. I would now like to give the floor to Timothy MacDonald. Timothy? You represent one of the largest multinational companies, and that certainly puts you in many, many different situations in many countries where you would request tax rulings. So could you please give us a global picture and identify which jurisdiction, which country is the most useful to you in terms of advanced tax rulings?
Be here. I'll start with the evolution for P&G on tax rulings. We've been doing this for 15 years. And our original objective has been superseded and evolved. So I would think the most important ruling is a point in time. The goal for us originally was to have financial coverage. And that meant our largest transaction volumes and our areas of the greatest uncertainty. But what brought us to the ruling process often was an audit. So in many cases, UK would be a good example. We had a very intensive audit. It took 6 years to resolve the transfer price dispute. By the time it was agreed, there were 7 years of open tax dispute, and they gave us a 5-year ruling prospectively. So we in effect covered more than a decade with that one ruling. And fortunately, it was not a very large cost for us. But let me give you a little background as to what needs to be true, because this is sort of a practical view of the considerations. Unlike an audit, which can be an adversary environment, if you're pursuing an advanced pricing agreement for transfer pricing, you must be very transparent. It's a voluntary system, and the governments make it very clear as part of their rules that if you don't provide all the information that they find interesting, you could be discharged from the ruling process. And if you're halfway through a ruling and you're discharged, it may actually be a much worse setting, because now they're going to wonder why you're not transparent. So as a practical matter, you need to approach a ruling with the assumption everything is transparent. You also need to have a very compelling logical business reason. If this is strictly a tax presentation, if it doesn't make a lot of sense pre-tax, you will not get very far. And even if you get a ruling, I would argue that many of the companies that are in the newspapers in the last 5 years with controversies about transfer pricing, they got there because they did not have a credible business reason. They pursued something that ultimately was too good to be true. So you need to be committed to that. My next 2 points is this will effectively be an audit for the company. So you need full staffing. You need your management to understand they'll be part of interviews. There'll be site visits quite often. And you'll need external resources, budget, and your internal resources to present all the information as if it's an audit. The best way to think of an advanced pricing agreement, it's a scheduled, managed audit. It's at the government's and taxpayers' timing and control, but is still a full review. What helps practically is that you have a single business model to present to the tax authorities. If you're a conglomerate, the practicalities of getting a transfer pricing ruling are more difficult because each business unit has different economic drivers, and therefore it'll be more difficult to explain each of these business models in one set of rulings. Likewise, it's better if it's the same business model in every country you operate, and I'll explain that a little further in a moment. Ultimately, practically speaking, it has to be self-interest for both sides. And I'll go through what I think are the self-interest motivations. And patience is probably the last thing that the taxpayer needs. The fastest ruling we've had so far took about 7 months. And it was strictly because it was New Zealand, but they had piggybacked, followed the Australians, who was actually our business hub for New Zealand. And the Australians had extensively audited us. We had a history of rulings. They reviewed all those documents and got very comfortable quickly. Our longest APA application was 7 years for a 5-year ruling. So to say it differently, the ruling was granted 2 years after the end of the ruling. But the good news is all that information was productive, because the renewal was 6 months later, and that was prospective for an additional 5 years. And it did pay off. It just took the second cycle for it to pay off. We've never presented this list publicly before. I've shown it to many governments, but this is where we have our rulings. We have 16 current rulings in place. 14 of them are bilateral. The 2 that chose not to be bilateral, it was the government's idea. We prefer bilateral rulings. We have an additional 11 pending, and a number of future prospects that we are very interested in pursuing. As I started to explain, the rationale and strategy for us has evolved for transfer pricing rulings. Originally, it was either where we had a large controversy or where we had a large business. So it was an efficiency point for us. It was tax department management of audit process and those kind of considerations. As you look towards the lower part of the list, particularly the ones we have not yet done, Russia being probably the exception because it's a very large market for us, but some of these other countries are smaller, but they're part of a newer strategy which goes beyond financial. It's a reputation strategy. What we now want is to have rulings in each continent. We want to have rulings in developing countries as well as developed, and we want to pursue countries that are thought leaders. So if a tax administration is tough and they have a great reputation, for us, the dividends are higher. If we get essentially a seal of approval after an intense process, it validates our ongoing strategy to other countries. And so the strategy has changed over time. So why does a company pursue it? This may not be obvious, if you're not in a corporate seat like I have, but as I originally kind of implied, we originally were focusing on certainty on a certain percentage of our business globally. When we complete the over 25 rulings, those that we have and hopefully maintain, as well as those that we're currently negotiating, we'll have covered 70% of our cross-border transactions around the globe, which is a very large accomplishment and gives us a lot of certainty. The predictability of earnings, there's 2 components to this. One is, as you execute the strategy I'm describing, and you have a consistent ruling by multiple countries, I'll just broadly state Europe. I don't need a ruling in every EU jurisdiction. If I have a ruling in 12 of the EU countries and the outcome is the same, when the next country comes to audit and they want a very different result, one of the conversations we have is, we run the business the same, 12 other governments have already agreed this is the same answer. Why is it different in your country? And so what I'm saying is, there's almost like a halo effect. If you do this well, you get coverage beyond even the countries where you have rulings. Practically speaking, the greater the coverage, the less I need to worry about transfer price reserves, which is by far our biggest tax issue. Our supply chain is complicated. Almost every product we make has cross-border transactions, and as a result, we can conceivably be managing double taxation risk around the world that's multiple times our total amount of tax that we pay. So for us, getting predictability means we can decrease our tax reserves dramatically over time. We've actually reduced, in the last 10 years, even though our business has grown, we've reduced our tax reserves by over $1 billion. And that's because of uncertainty and caution. We had reserves we actually didn't need. And as I point out in the bottom bullet, the financial community gives you no credit if you later discover you don't need a reserve and you release it, because the U.S. financial disclosures, they call out separately the historic reserve release, and they don't count it as real earnings. And so as a result, it's wasted earnings. So if I can help the CFO eliminate that wasted earnings, the quality of our earnings goes up. And that's a very compelling financial community imperative for transfer pricing strategy. Additionally, more more specific to myself, we have a large department. Worldwide, we have 200 plus people, but we operate in over 100 jurisdictions. If all the governments show up on the same day and want to audit us on transfer pricing, we can't respond. We don't have enough resources. So the ruling process is a way for us to schedule and manage capacity and allow us to cover more audits efficiently. Typically, they cover many years. The norm we see is 5 years prospectively and often a rollback if in fact we have an open controversy or open audit years. And one of the reasons for that is the same group, the mutual agreement procedures that are part of the Competent Authority Office, they typically are the ones that manage both the APAs, which are prospective rulings, as well as treaty disputes where double taxation cases exist for the past. As I alluded to, another thing that affects us is reputation management. As a practical matter, P&G is a very large company. We're going to get audited anyway. So for us, it's not a question of do we get audited. It's much better for us to be proactive and share with the government and have that discussion and not wait for the audit team to show up. Additionally, I think the national office, which is where the APA programs are usually managed, they're much more sophisticated, they're much better trained, they understand the treaty commitments and broadly the OECD and UN transfer pricing rules, therefore it's much more predictable. The second bullet point alludes to reputation risk. Increasingly in Europe and the US at least, there's a lot of new stakeholders that are not our shareholders, they're not the financial community, they're non-government groups that want to talk about fair share of tax. I don't know what fair share is. I know what the law provides, but fair share could be all my earnings, or it could be something less than that, but it's not defined because it's a personal judgment, it's a philosophy. What I do get comfort is that if we have two governments that have opposite interests, and they've both reviewed our position, and they agree on the facts, the odds are we got the right amount. And so I think it's a reputation protection for us to have these kind of rulings beyond the financial considerations. And why would a government do this? Well, I think number one, transparency is an advantage for governments as well. Every economy is seeking foreign direct investment. And if you can provide predictability, you can have greater expectation to invest and get a return. If you have uncertainty, every business opportunity has to be discounted for the expected uncertainty. Additionally, it's a concentration of resources. Many governments have concluded they can execute and cover more transactions consistently with less time by running it through their central office. Equally, there's a coverage of the treaties. The overlap of the treaties and your APA jurisdiction are viewed as usually concurrent. And both of them address the need to avoid double taxation. So I think there's a logic there. Lastly, or in concluding on the government's interest, I can't speak for every government, but I do observe it's very widely a developing trend that APAs are more popular each year. More governments do it, and they do it from their central office, their national office. I think it's because transfer pricing is difficult. Transfer pricing is not a precise measure, it's an art. In OECD terms, it's an arm's length range. Well, that's a lot of judgment. It's a lot of economics. Most of your transfer pricing analysis is not involving a competitor. It's analogies, and those analogies you get better the more times you do it. So I think it's a logical efficiency and quality control for a government, and it allows the governments, I believe, at least this is what I've been told, for them to cover more taxpayers with the same amount of resources. Finally, not every APA is perfect. It's not a perfect answer, but I think it's a good one. Number one, we have had a couple that have failed. Two of our APAs were revoked by the government. We had a new administration, or we had different authorities within the same government, and they had different points of view. Both those circumstances were unilateral rulings, and in those circumstances we did get them back on track, but it took multiple years. I think APAs are a tool to deal with uncertainty. They're a tool, but you have to understand transfer pricing itself is not precise, so you can't assume this is going to solve every problem. But working with the national office, I think it does bring you a higher level of specialization and expertise. And lastly, transparency and patience. I'll conclude with that. It's the most important thing as a taxpayer you have to use to approach an APA program.
Спасибо, Тимоти.
Thank you, Timothy. But yes, supposing you've got rulings from many countries, where's the best balanced system in which country?
System. The one that took the longest, but actually it solved the problem the best, was the UK. Our difficulty there was the audit team was relatively inexperienced in transfer pricing. And so of the 6 years I mentioned, the local audit team had the case for 4.5 years. When we finally elevated it to the national office at HMRC, there was a very pronounced change in tone. They did visit the counterparty countries. They did interview 30 management. And within about 14, 15 months, we had a resolution, and it made sense, and it was consistent with other countries.
Спасибо, Тимоти. И, может быть, еще...
I have yet one more, not so much question, but I seek your opinion. This ruling is given to a specific taxpayer who applies for it. Do you think that the position that is stated as a result by the tax authority based on the specific taxpayer's application, can it be made public so that other taxpayers could follow it going forward or not?
I think it's difficult, and the reason is for transfer pricing analysis to be valid, you have to describe your business model in detail. You have to describe trade secrets. You have to describe your strategy, your global future strategy, and the expectations of management. I don't know how you can make the ruling meaningful if, in fact, you disclose all this, the taxpayers then can't participate.
Спасибо большое. Коллеги, я бы хотел...
Thank you very much. I would like to give the floor to Chirachavi Intachan. My question specifically as follows. Chirachavi is an important expert on tax mediation. And in our project, we had this idea to rely in the most complex disputes, some experts, specialists, third parties. What do you think, Ms. Intachan? Would you think it is relevant for tax rulings? Is it allowable for tax rulings? And what do you think in general about mediation in tax affairs?
I think actually mediations itself help in the case that the case comes to the court, and it can help alleviate or reduce the backlog of the court. And in the problem that you discussed about advanced tax ruling, right? In the same terms, it could reduce the case that come to the court too, because you prevent the case before going to the court. It's not like a mediation. Mediation, like you let the case begin, and after the case begin, court we think that, hey, what should we do with a lot of cases, right? And in Thailand, we experience, we have tax ruling, advanced tax ruling also, but it's not binding at all. Although the Revenue Department issue the tax ruling, and I mean the private tax ruling. And other authorities, I mean in the RS, made things different. And sometimes, I mean, the court, when we see the case, we don't think the same, right? So it has no binding in the revenue, the ruling. So, but now, because our new government, we have the plan that we need some certainty that everyone mentioned. So uncertainty is damage our, the investment for the global investment, and we think that we should make something clear. And this idea is just come up and supposed to, now we are in the tax restoration process. We make the new law that like a heritage tax, and we would like, we change the tax like a property tax with a new idea that people have to pay the inheritance tax, something like that. And this is now collect in the model that, all right, now the certainty have to be in Thailand. So, and we have borrow the idea from other countries like US, that, okay, you have to pay the fee, but anyway, it should be binding, right? And come up to my presentation that I just would like to show you that how the mediations is work in Thailand. So if you have a case in Thailand, so sometimes people think that tax cannot be mediated, right? And there is a problem that how can we deal with mediations in the tax court? Can I begin my presentation now?
No.
All right. Okay. So this is normally, this is a normal proceeding for the taxation in Thailand. Maybe it's the same with other country. We begin with tax assessment and use the 30 days rule to appeal committee. And 30 days rule also apply to appeal to the tax court. And after that, about like sometime 1 year or 2 years, the court can make the decision and give the judgment. And it will go, if you don't agree, the disagreement, you can appeal directly to the Supreme Court. And it may take a lot of time. I mean, sometimes it's 3 years or 2 years, right? So for the taxpayer, I think it's too long for them, about 4 or 5 years to get the result. And there is the same case in the other transaction that should apply the same rule. So with this risk, Thai court try to bring the alternative dispute resolution to resolve the problem about the long time that waiting for the court decision. We apply the Civil Procedure Code of Thailand. Actually, it exists in section 19, 20, and 20 bits for the Civil Procedure Code. And it specifies that the court may mediate the case at any time. And not until like 1997, we use it because like at that time we have, and if you remember, like it's a Tom Yam Goong crisis at that time. We have a lot of cases, financial, bankruptcy, go to the court. And we try how to manage the cases. And the president of Supreme Court issued the practice guidance for the mediation at that time. But at the time, it's just like the court annex mediation. It's been like the judge will be the one who mediates the case. Like in the tax court also, we begin the mediation in the tax court in 2002. And the Central Tax Court issued a rule. It's called regarding mediation for the dispute settlement. So there is a number of cases come, and we have a list of mediator. Okay, and there is the order of the court that have tried to establish the list of mediators. But the first time that I told you, it's just a judge only, because it's a new system. In my country, if you are a mediator and you are not a judge, it's very hard to conclude the cases. And anyway, because we want to do it like international, we make now, we call the mediator who registers to the court is a private mediator, but you have to register to the court first. And it's proved successful rate for the mediation in Thailand. It's growing. In the beginning, sometimes like people think that, hey, I don't know how to mediate a case. I don't know how, if we go to mediation, is it work or not? So it's very little cases. But it's growing number. But it's not much. But it's still working sometimes, because like you see sometimes the case come to the court like 50 cases for mediation. But normally in Thailand we have about 200 cases per year in the tax cases, not very much. Maybe because it's already settled in the revenue department already. Right. Okay. To refer for the mediation, this one. Actually, we have a type of cases, many cases. Before this, all cases can go to mediation, but we found that it's not successful. Because some type of case is just, what is called, it's just the order of the state, order of the authority that may not be mediated. So we just select some cases, like the case pertaining to the government claims on tax debt, and also the case pertaining to the right and obligation made under the agreement of the purpose of tax collection. These two cases, the two type of cases that we go to mediation. It's made different. I mean, like there is the concept of the mediation before trying. I mean, like the concept of mediation in the revenue department processes, which may select the case that different from this. Okay, and I will explain later. Okay, and the mediation can begin maybe sometime before the pre-trial or after the trial begin. I mean, it depends on the request. We're so open about this, as long as the case will not be, the party will not abuse the process, right? Because sometimes they would like the case to delay and use the mediation as a tool to delay the case. Okay, and when there is the mediation, the case shall suspend the proceeding, right? All proceeding will suspend. That's the point. I would like to make just to tell you about benefit, a lot of benefit of mediation. It's reduced the backlog of the case in court, provide the different forum from traditional court, and provide win-win solution. I think at the end, the taxpayer will feel more relief. The point that I can find in the mediation process, I mean, like IS may borrow this mediation process to use. The one thing that the taxpayer always thinks is that they think that they like what is called when they come to the court, what they want, apart from pay less tax, they think that they would like to speak out what in their mind. They think that sometimes Revenue Department did something bad, aggressively, or abuse the power sometimes, right? It's happened. And what the taxpayer just want to speak out. And okay, judge, I am ready to pay tax, but let me speak. What happened to me? That's the way. And it can be ended by the mediation. And the process not, do not take time like 5 years, no, just 3 months, it's finished, right? And this will, make the taxpayer relate and feel good, maybe understand the situation of the Revenue Department. This is the best thing that I can find when I mediate the case. Okay, so the other point that I would like to make, there's some obstacle, sorry, because some obstacle to the mediation is like the concept of the mediation first come from the normal party, not one state and individual, right? Mediation is work very well in civil cases, not in the case that between state and individual. So it's a fighting between the idea that how we can mediate something like this. But from our experience, it's work. At least you can see the statistic that I give you earlier. So the other thing is the mediation tax dispute. I mean, it's very, reluctant if used in the case of Revenue Department, because it's about power from the case by case basis, right? So the tax authority think that, all right, I don't want to mediate the case because, it's a risk that I didn't do my job or I may make something illegal. So that's why in Thailand, the Revenue Department still, not respond to the mediation. I mean, when we invite them to mediate, they're still, all right, I come and I will do my best. But the idea of this still, struggle. Because I still think that they are uncomfortable to do this, right? And I think we may take 2 or 3 years for them to understand better. And the big concern is about, they think that the mediation process may be a forum for them to avoid, for the taxpayer to avoid tax. So what happened between the people or the taxpayer that always pay tax legally in time, compare with the taxpayer who always avoid tax. So how we balance this situation, right? So that's give you some idea about settlement of dispute before trial. We have advanced pricing agreement in transfer pricing cases in Thailand too. Have revenue ruling that I tell you that is not binding, but we government try to make it binding and try to make legislation about the binding of the tax ruling. Okay, that's the end of my presentation. Thank you very much.
Thank you very much for your very interesting presentation. I turn to agree with you. This psychological issue is quite important. We see taxpayers who come to court. They may not have a clear-cut position, but they want to relieve, to unburden themselves. We see that also in their applications. And I think they probably should be granted this right, because the lack of an opportunity to speak is maybe important.
Question to you would be addressed as to the representative of the Thai court system. Would it be so kind to update me, what the chances for taxpayer in Thailand to be jailed in case if some taxes would not be paid properly or untimely?
Right. We are very generous for taxpayer actually. Have different view. Because normally the chance to be jailed for not paying tax is very, very low. And sometimes it's involved about politics. There is a big political cases involved with the politics in Thailand and about not paying tax people. But still no jail about this one also. And that I told you, the chance is really limited. But now, because you know what? Because the cases, criminal cases, not go to the tax court. It's go to the criminal court. And they think that compare the other criminal commit, so commit the criminal in tax is so little, it's not very harmful, so that's why. But now, I'm not sure this is good news or bad news, but we will draft the law, have a plan to draft a law to make all the criminal cases about the taxation to the tax court. So I think it may be changed after this law is already issued. Thank you.
Спасибо большое.
Well, thank you very much. And dear colleagues, we have been discussing this for a while, and we have most focused on the positives. It may seem that there are no problems at all. Well, this is because the idea behind it is very positive, and it's very clear to everyone. And that's why we keep highlighting the advantages, sometimes not mentioning some of the flip coins. But we have a representative from the academia, Sergey here. And as with other things, the devil is in the details. Therefore, given our approach, our concept, and other experiences, Sergey, what risks do you anticipate here? What potential pitfalls and what implementation errors could result? Sergey Ashotovich, thank you very much for giving me this opportunity to participate in this highly representative meeting of experts, and your introductory words when you segued to my presentation have set a certain tonality for my presentation, meaning you expect me to be critical. Nevertheless, overall, I do agree that legal certainty is a very positive idea. It has always been a driver of legal development. This is something generations of jurists have fought for, and of course we would like to see a similar level of certainty in tax legislation as we see in procedural, civil and other fields of law. Of course, it would be great if we knew all the tax legal consequences of our actions in advance. However, yes, indeed, the devil is in the detail. Therefore, I would like to address some rather philosophical considerations towards the end of this discussion, some general thoughts about the evolution of tax law in Russia and the possible options, the possible approaches that Russia could pursue towards this idea, because we have seen a plethora of new ideas mushrooming recently. Each of them seems pretty well-meaning and benevolent, but as an observer, as an external onlooker and researcher of these different processes, they sometimes remember tinkering, piecemeal efforts. They're very fragmented. Sometimes you see constructs emerging that invite more questions than answers. So what about the underwater rocks, the pitfalls that we need to take into account while borrowing the best international practices? I'm not saying that we should be skeptical about international practices, that German, other Western experiences are not applicable at all in Russia, not at all. But clearly, our taxation system has, as a result of rulings by the constitutional, the higher arbitration courts, a number of peculiarities, in particular the principle of collecting taxes on the basis of the law as the supreme political force has always determined enforcement and established a level playing field for all taxpayers. Of course, there is some element of uncertainty in the law as well. It's not without its defects, especially when it comes to tax law. However, as we fight and strive for more certainty, we shouldn't go too far. We shouldn't limit ourselves to individual instances of certainty, because we may end up making individual agreements with each taxpayer on the amount of tax collectible from them. That would be taking the situation to the extreme and achieving full certainty on it. However, we are precluded by a number of constitutional principles that have both legal and economic significance. For instance, the principle of equality and universality of taxation. This is a norm that not only ensures equity, but also creates a number of important economic prerequisites, such as market competition, market freedoms. Therefore, tailored solutions in matters of taxations may compromise that principle. This is a risk. Therefore, as we try to critically analyze this new construct, we should be mindful of these matters and risks as well. One thing we would like to avoid if we decide to pick up this option would be to create an elitist mechanism that would only work for a selected few. It should not benefit members of a closed club or circle. Let me put it like this. I saw the presentation by the tax authorities today, and it seems to me that only major taxpayers may be eligible to this scheme. Yes, I understand the rationale behind this perfectly. One reason is that these largest taxpayers are really few in numbers, and they are the ones that make the most complex transactions. The tax service doesn't want to be overwhelmed with cases, and that rationale is certainly clear. This is the rationale that was voiced back in 1994 when the Constitutional Court was considering the constitutionality of special treatment regimes for major taxpayers. And I remember I wrote an opinion together with my colleagues for the Constitutional Court, and in that opinion we were very much in favor of that special regime. This was upheld by the Constitutional Court in that, yes, matters of administration can be tailored. But when we discuss this concept, it's not only about administration, it's also about interpretation of laws. It concerns the very essence of tax obligations, the amount of tax obligations, and the timing of tax payments. So it has to do with material tax obligations. Therefore, differentiation between various taxpayers depending on their size in terms of their access and eligibility to more certainty about their legal status. I think this is, at the end of the day, a constitutional matter. This is why I thoroughly enjoyed the foreign colleagues' presentations that I heard today, because they seem to be imposing restrictions, not on who is eligible to use this, but they rather tend to restrict the different matters, the types of cases that can be put through this procedure. I mean, you could establish criteria only to select cases that present the most complexity. And you may be aiming to expand these criteria down the road. Among other general conceptual risks, I think I should remind you of this. Legal certainty in tax matters has always been ensured through three approaches that work differently at different stages of our tax system's development. One approach was legislative, in other words, legal development, improving tax legislation, addressing ambiguities and inconsistencies in our tax legislation. This is an important approach indeed, because sometimes our lawmakers and other stakeholders seem to be tempted to delegate everything to those who apply the legislation, relieving themselves of the duty to improve legislation further. They have enabled the tax service to interpret the law. The Ministry of Finance can interpret the laws, and why should the lawmakers bother about improving, perfecting the existing legislation? The second approach is through case practice, case law. Over the past years, I must say, tax law has achieved more certainty mainly through court practice, through court cases. This has resulted in the overburdening of our courts. But they have presented us with a number of legal positions. Recently, the burden on the courts, the backlog has decreased, but I don't think that backlog consideration should really be the guiding considerations when we choose our approach. So case law shouldn't be disregarded altogether. I think it has a role to play. We know that tax law is fraught with conflicts and disputes because of the different capacities of the different parties, their different standings. So case law has a potential which hasn't been exhausted, because case law is all about adversarial settlement of disputes. It involves interpretation of laws, arm's length, impartiality of the courts. Case practice is very important, and regardless the legal system. So I wouldn't completely disregard this channel, this avenue, in particular in terms of appealing rulings, because as we know, this mechanism can be both forward and backward ruling. Forward-looking rulings are a way to preemptively settle disputes or prevent them from happening, and in that case those rulings should be final. But if they are final, well, there's every reason to introduce an element of appeals so that court review can be applied. In that regard, I should also mention the recent judgment of the Constitutional Court of the 31st of March 2015, in which court confirmed that interpretation of the law can be a subject of a complaint, appellate complaint. Of course, there are certain limitations here, and what they were talking about were abstract interpretations that are issued for an indefinite range of taxpayers. Nevertheless, importantly, according to the Constitutional Court, those decisions can be appealed. Next, the third avenue to be pursued is an administrative one. The administrative way of developing tax legislation, but this is something where we should really get our record in order, because the current state of regulation in the field of interpretative letters and circulars, I think the current state of things there is completely unsatisfactory. According to the tax code, the function of interpretation rests with the financial authorities. This was the position of our leadership during the administrative reform of 2003-2004. This was embedded in the corresponding presidential decree. Control and oversight were given to this agency, whereas interpretation of laws and the issuance of interpretative acts were delegated to the ministry. So there was a separation. Those who supervise should not be the ones to interpret or to augment tax legislation. In that respect, the addition to the tax code, the idea of the substantiated opinion of a tax authority, that principle, which was introduced to the tax code, in a way, to some extent, compromised that framework. I mean, there should be a dividing line between interpretation provided by the executive authorities, interpretative rulings provided by the ministry, and now we have a new type of opinion making or decision making in the form of advanced rulings. So I think we should be very clear on which entity, which department will issue these rulings. I certainly agree that this should not be left to regional or local or tax authorities. It would represent a step forward in terms of consolidating and unifying tax application practice. As far as the headquarters is concerned, I think we should also think of ways on how to involve the business community and the expert community into this decision-making, into the process of formulating rulings, or at least perhaps on the level of conciliatory mechanisms to reconsider those rulings. And perhaps this could be linked to the Ministry of Finance as the body that is responsible for coordinating enforcement practice in tax matters. On top of that, I should also mention the consequences that may arise from adopting this new system. Again, what are the specific exemptions that they will entail? Will they exempt taxpayers from fines, fees, or litigation? I think the principle should be this. It is not the ruling that is binding. It's not the motivated or substantiated opinion that is binding. It's the law, the principles, standards of the law that are binding upon the taxpayer. Therefore, the duty to pay taxes cannot be exempted from based on an individual act of a tax or financial authority, which may be erroneous. However, this arrangement is not in the tax code. There are no exemptions from tax payments on the basis of individual decisions. As far as the fines and other penalties and sanctions are concerned, yes, those could be included, because if the taxpayer demonstrates enough good faith by applying to the tax authority for an advanced ruling, I think this is sufficient reason to exempt them from paying fines. I have not covered every aspect I wanted to share with you, but at the risk of tiring you with my ideas, I think I should leave it there. Thank you very much. It is an interesting matter indeed.
particularly in the context of horizontal monitoring and tax rulings. We have to consider these issues, and I agree with you. We might want to think not so much about the taxpayers as about the issues that should be covered. Some of the issues that you raised is purely specific to Russia, but I agree with you that we need to make sure that all tax resolutions and resolutions of the Ministry of Finance should be differentiated. Some of our resolutions can easily be recalled, but then if we do that, would the taxpayers enjoy it? Would we achieve certainty? Because our instructions pertain to the entire territory of the Russian Federation. If we recall them, we'll go back decades ago, whereby all territorial branches would have their own unique positions. This won't lead us anywhere, I assure you. I think that's our resolutions as part of the horizontal monitoring and the positions that will be formulated as part of the advanced tax ruling will be different from what the Ministry of Finance may offer. Those rulings and horizontal monitoring are mini audits. They are not just explanations in theory or explanations of the law. We will be analyzing the documents, we'll be analyzing the transaction in question. So this is somewhat different from what you have intimated. We might just want to make it more clear. As for courts, we are very respectful of the judiciary, and we do not exclude our courts, but what we want to see go into courts would be the most sophisticated, complex disputes, because our courts are overburdened as such. Our courts, particularly tax courts, may do better, may have been doing better recently, probably due to the evolving administrative procedure. I don't think we need to be concerned about courts when we discuss taxes. This pre-trial procedure in Russia only works for taxes. Russia has a horde of other issues litigated in courts where they could do better with mediation, or pre-trial solutions. So other disciplines, not just taxes, may benefit from mediation. And I don't think our courts would be empty at any day in the future. That would never happen at all. This is utopic. To Anki. I might agree with you that the issue of appeal against the substantiated resolutions of the tax authority, we shouldn't deprive our taxpayer of remedies available to them. And thank you very much anyway. So, by way of a summary, you have heard about our initiative coming from the tax authority, but I wonder what our business thinks about it. Dmitry here is representing the entire of Russian business, so he has the floor. Thank you very much. I enjoyed very much Timothy and what he told us, and I want to start by business motivations, and then we could move on over to some legal matters. Some of the research that we've done when we started working on the tax monitoring, the world practice seems to suggest that the number of of judicial procedures in tax matters should become fewer and fewer, and we should prefer some anti-date or pre-trial controls. So this is an important trend which we must probably borrow, and I would refer you to a specific example, a case we had with one of the tax inspections, and also a very good example for our discussion. We are doing telecommunications. The transaction may be a few kopecks worth, but when you multiply it by the numbers, you get a very important tax implication. One of our old disputes had to do with as follows: to arrive at some truth. For the purpose of our disputes, we had to prove for millions of transactions to prove our point, to show how it worked. For this kind of approach may be ideal from the point of view law, for any ideal kind of settlement, but for business it doesn't work. And the fact that the world system seems to be moving to a situation whereby there will be fewer litigations and tax courts as the final definition of the tax position. And this is the trend that we should take on board. And I'm not arguing with Sergey. The trend in itself should be allowed. Otherwise, our business will be suffering more than it would benefit. Finally, if you compare tax administrations, you would see that advanced mediation, advanced discussions, and the principle of cooperative compliance, where you tend to resolve issues outside of court and talk about the dialogue between the taxpayer and the tax authority. This is another global trend, and I would think we would risk a lot if we go against this trend. This doesn't mean that we don't want to use courts at all, but we think litigation in court is an extraordinary situation, should be an extraordinary situation. And finally, we discussed various elements of the tax policy. What do we say? What should be the function of the tax administration? The function of the tax administration has to do with the cash flows. And the next important factor for us, the tax function, the amount of tax paid is the function of the tax risks assumed and the tax assets available. Given we have the minimum of tax risks, and given we want to be considered a bona fide taxpayer. So the business does want to manage its tax flows because it's a financial function, but it should be happening in a very comfortable and risk-free environment for the taxpayer as well as for the government. In other words, this kind of approach, this kind of a tax position on behalf of business presupposes, and this is important and correct, it presupposes a very close interaction with the tax authority, the attempt to disclose and to minimize tax risks so that your cash flow management pertaining to tax would be as comfortable as possible for the taxpayer as well as the government. Specifically, what sort of tools can we avail of in our tax strategy? We don't want to assume risks in the category of probable, and we want to manage the possible risks. From the point of view of financial management, in the situation where we have a risk of 50 to 70, Our policy says this risk should not be in existence for more than 18 months. You may think it's strange, but we do appreciate that any tax reserves or any possible risks which are material could become very costly for our business from the point of view of funding, from the view of reputation and cash flow management as well. So we have a very rational question. We need to manage this. And our third position, again, has to do with accounting in a way. What is management about? You need to minimize differences and maximize the process. You need to make sure you do the maximum possible, and you can't do it if you have the horizon of 3 to 5 years. If you remember in my first 2 slides, I was saying that we're very close in Russia to implement this advanced tax ruling. Why? Because the tax authorities, A, competent, which is true for today. B, they are in a position to approve this decision. And 15 years ago, talking about tax rulings would be irrational, would be irrelevant, because both parties would rather go to court. Today, now that the tax authority has the competence, willingness, and the duty and obligation to accept this institute rather, I think we need to do that. And the business, the larger business in particular, is ready to embrace it. They want to have the certainty today. It is more important for their cash flow than having these settlements in 5 years' time. This is an important factor for business, and it seems to show that this implementation can succeed. I'll flip through a few slides because of the time. Now, if we are to talk about the tax explanation and about this concept, we don't want any competing competences. We have the Ministry of Finance, we have the Federal Tax Authority, we have the court, and we need to resolve the kind of a conflict they have between the three. What we could say here, what should be, from the point of view of business, the scope of the tax ruling? It should be the interpretation of the tax law vis-a-vis specific business transactions or deals. From our point of view, this could give us a mechanism, a potential mechanism of settlement or resolution. In the arbitration, there's this notion whereby the parties can agree based on specific circumstances. If they agree with this or other rule, they agree to the specific facts that could become the basis for a specific decision. And this could be an option for the tax ruling. We're not saying that the tax ruling is to interpret or construct the law. This is more like an agreement, or a bargaining agreement between the tax authority and the taxpayer pertaining to the interpretation of the specific tax circumstances for the purposes of the tax law. Of course, you could ask if there is certain uncertainty in law. Without interpretation of law, you can't make any tax ruling. Then, in this kind of a situation, the tax authority or another agency that will be issuing those rulings may need to go to the Ministry of Finance and agree on that position. And another important factor is the fee. I believe the tax ruling should come with a fee. Because this may be cutting off ineffective, inappropriate questions. It is important, but there are other factors that may be extremely important. This may be specifically a Russian thing, but the fact that you pay for a very detailed, specific consideration of your position would mean, firstly, that the Ministry of Finance going forward, and we hope it will happen, will not be accepting a position which would be contrary to the ruling. And secondly, that's possibly, and again we're hopeful, and this will be the end of this process, that it could be the source of financing, paying for the analytical resources to be evolving and developing at the tax authority. So if I'm asked whether we should pay for the ruling, I would think, yes, we should pay for the rulings, and but then for the tax monitoring, and I think this the tax monitoring and cooperative compliance, at least vis-a-vis the larger taxpayers, should be a priority, and the government should be stimulating the taxpayers joining that regime. And of course, we would love to discuss this possibility whereby the taxpayers could see their tax ruling fees discounted if they are compliant. Another thing I want to discuss with you is the subject of rulings. Of course, we could discuss what should be the number of different issues discussed, but there could be situations whereby the interest of the business would be not so much the transaction, but some other specific facts of their business life. And the scope of transactions or deals, subject of tax ruling, is something that we need to think about. What I could suggest is this: there's something that the business want to see, this tax rulings, and should it happen, the business community is prepared to analyze certain types of transactions or even sectoral deals that the business would want to see included by the tax authority in their future tax rulings. So the conclusion is we are seeing this very straightforward case where I could say this institute, this specific mechanism is better to be than not to be. This, I think, is the position of the business that I represent. We are very much in favor of having it implemented as soon as possible because it is promising, it is appropriate, this is relevant, and this is beautiful. Thank you very much. Thank you very much, Dmitry. What can I say? We see the will, we see the willingness, and until the end of this year, I think we will have it finalized. We don't have that much time left as a result. We might want to get together and work on some finalized concept that would suit everyone. We're moving towards the end of the story. We may have a maximum 10 minutes for your questions. I'm coming from the business side as well, and I have this question which may be appropriate as a follow-up to the presentations we've heard earlier. When do you think this initiative can be implemented? Will it be part of a law? Will it go through the State Duma? And given the changes in law, whereby law enforcement doesn't have to have the presence of the tax authority if they want to start an action based on some tax issues. Do you think law enforcement, local police would be guided by the tax ruling? Would this tax ruling be enough for us to say no, Mr. Policeman, no, it does not work? What do you think? Well, dear colleagues, let us be fair. The president has decided, as far as the criminal cases are concerned, you remember that we were very much concerned about the possible abuses. This law about the procedure whereby tax criminal cases shall be instigated. I have the statistics. It appears that so far law enforcement were acting adequately. We don't know what will happen going forward, but of course we cannot exclude a situation whereby investigators, prosecutors could decide to ignore tax authorities. We can't exclude this kind of a situation, and I think it's nothing to be concerned about.
Therefore, just as I say, so far we have not seen abuses on the part of the tax authorities. I have some statistics, and I can tell you that I'm convinced of this. Yes, please. Dear colleagues, this is my question. You know, the existing system of regulation already provides for the obligation to provide explanations both to the Ministry of Finance, and this is the obligation of the tax authority on the federal and regional levels. In the process of discussions with our European colleagues back in 2008, we realized that the system we already have already contains this private ruling practice, and we said back then that the only disadvantage of this system versus other systems was that when you are obtaining an opinion these days, it's only this ruling or this opinion is not really binding. It only exempts you from certain fines, and it is not binding upon the financial or tax authority. Should we really be trying to erect a Chinese wall between the system that we currently have and the would-be system that we are planning to have? From what I understood, the biggest concerns have to do with uncertainty, right? Because at any time a financial authority may renege on their own position that they had in the past, which certainly creates not only uncertainty but also the lack of responsibility while issuing decisions. We know that in the current regulatory system, the Ministry of Finance already has investigative powers to scrutinize various facts and circumstances. A number of circulars and letters have been issued to that effect already. So should we really be making a transition to a system that only includes the big businesses, that offers different regulatory solutions to them at a certain fee? Because if that system is introduced, there will still be government fees. This will not create any financial incentives for the businesses, because that's the only way you can go about this in our budget system. Let me respond to this, and this is a great question, and I hope to oblige you and accommodate your concerns. Let me make a reference to a very interesting situation. When the Ministry of Finance adopted a standard called evaluative performance indicators, this has led to a very interesting situation. The accounting rules say that you should create reserves for decommissioning fixed assets that occurred in the middle of the year. But then there is also the principle of rationality of accounting that says that if you can appraise an effect in your reporting, you don't have to account facility by facility, but our federal legislation says to the contrary. You need to work facility by facility, asset by asset, and that created a legal inconsistency. How can you evaluate, assess, and pay your property tax under these circumstances? The Ministry of Finance wouldn't have been able to resolve that situation because they would have had to take into account a lot of factual circumstances, and they would have to recognize the actual practice of identifying these different reportable elements. Who can do that? Perhaps the tax authority is the agency that can do that. But there is a paradox. The businesses are prepared to pay for that exercise to the government because interpretation of the law, comprehensive assessment of the situation is a great need and can only be performed by the government. That's one thing. Next, I would like to say that there are lots of situations in businesses that go beyond law, that cannot be foreseen in the law. For instance, ERP operations, management accounting, and so on and so forth. There will always be inconsistencies. There will always be business processes based on assumptions that are not provided for by the law. Without a careful analysis of the situation, you cannot do it. The Ministry of Finance is not going to do it. So there's a very, very strict, very big division here. I think that what businesses need is plank by plank analysis of their assets, of their accounting, of their transactions, and they expect the authorities to provide their very clear position on the way their business is structured. The Ministry of Finance is never going to be forthcoming in that respect. Yes, please.
Our experiences. We're not advocating there should be a fee. What I'm actually saying is we're willing to have a fee. Some countries for advanced pricing agreements have no fee at all. Others have a two-tier fee for small companies, small fee. Big companies, a larger fee. And to be honest, if that helps them get capability, get database access and hiring experts like economists, we think that facilitates the total costs being much less. So I'm not suggesting domestic law or big versus small advantage. I'm just saying that transfer pricing is very complicated. We're willing to pay to make the system work well.
Thank you very much. Moving on. Vadim Zarupov. Just to continue on this question of fees, and it's not really a question here, because what really is needed is transaction assessment. It's a big intellectual effort, and in any case you will have to pay at the end of the day for this exercise. The most untoward situation is when somebody applies for a ruling, but it's paid out of the taxpayer's pocket. Next, I think excessively high fees will be a barrier for small and medium-sized businesses, and it's very inflexible. Therefore, what I would suggest is this. The businesses could pay in the following way. When they file an application, they would already suggest an answer. I mean, they would provide their interpretation of the future transaction. They will provide their rationale, their justification. And this will stimulate the company to bring on board their internal, in-house, or external consultants. And what the tax authorities will be left with is just to say, yes, this is right, or no, this is not quite right, and then to provide the rationale why not. So if the law contains the provision that the tax authority is in a position to simply say yes to the suggested solution that will trigger a mechanism of free market-based pricing. That would be the most equitable way of setting the fee, setting the price. In other words, a stamp of approval is expected from the tax authority, right? Okay. Yes, please. I'm a lawyer. I have experience of litigating both in favor and against a tax authority. So as a practitioner, I have this big question. I think you said quite rightly that it's a matter of transparency of the company, but transparency is differently understood by different stakeholders here. The government and the companies understand transparency differently. You know, specialized tax authorities do not always have the same understanding as the lawyer or the accountant within the company. They see the situation differently. The tax inspector will never understand the company better than its accountant. The accountant is wise enough not to show some things to the tax inspector. So I have a suggestion. Why don't we try to be as detailed as possible about which documents should be requested and whether it should be voluntary or mandatory to provide documentation, or perhaps the tax authorities will be obliged to request additional documentation if they need it or if it was not provided. And how will decisions be made regarding on-site checks or inspections? Will it be simply limited to off-site inspections? And another question is, how will off-site visits be, site visits be documented? Because sometimes in the courts, we face this situation. An inspector says, I don't have first-hand experience of seeing this document, and then that creates a lot of controversy. I mean, there should be very clear guidance on how to document these inspections, reflecting what questions were asked, what information was looked at, because when we come to the court, you know, the court people are legal people. They are not knowledgeable about economics, and they have to make a decision. So they will be guided by a formalistic approach. They will take the documentation. They will look at what papers were provided. If some papers were missing, that means that the defendant is in the wrong, or perhaps the tax authorities may have uncovered additional documentations that shed light on new circumstances. So what I'm concerned, basically, is how detailed the tax authority is going to be in documenting their ruling-making process. And again, there is the risk of being too detailed. The letters from the Ministry of Finance that are typically issued, you know how the courts take them. They say this is an ad hoc response by the ministry to this particular company can't be transplanted to a different situation to the defendant. Well, I think I might want to argue with you about the courts not being knowledgeable about economics. I have seen quite a few cases where the courts would do a better job doing economic analysis than the defendants' representatives, the taxpayers. And I think at the end of the day, it's all about confidence. We should recognize that, yes, on both sides, the taxpayer and the tax authority have very little trust towards each other, but things seem to have moved on. Look at what we had 10 years ago. We've made tremendous strides, so it's just a matter of keeping up the good job and the momentum. Dear colleagues, I think we should leave it there. And I think I should extend my gratitude to all of you today. I thank the panelists, the speakers that we had today. Thank you very much for highly enriching and stimulating presentations. I wish you excellent time in the elegant city of St. Petersburg. Hopefully you will have enough time to visit or see some of the sites and landmarks here. Thank you very much.